So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about this lesson in not throwing your employees' shit away from Robinson and Priority Auto Huntersville Incorporated. It's an interesting court case. This automotive company hired James Beckley. He fixed a previous dealership and decided to make overhauls. And some of the overhauls were, kind of interesting, at least from a non-car sales perspective. For example, he changed where the car sales were finalized, and as a result, the that would leave associates would initially interact with customers out front, but then they would leave them to finalize the deal with the sales managers down the hall. And the idea was that it would be more efficient and welcome to finalize deals in the middle of the store. Robinson and Hall were both sales managers, but decided not to relocate to the new sales tower. All the other sales managers did relocate. They all moved, and no one asked them not to move, but they decided to stay put. And so as a result, sales associates never brought them the deals. And it wasn't a good deal because their pay was tied to these deals that the sales associates were supposed to bring. And so this is Robinson and Hall were both African American employees, and they alleged that they experienced racial discrimination during Beckley's first week. They said that Beckley apparently said, "Make Priority Honda great again," which Robinson and Hall considered that it was discriminatory and racist towards minority employees. In addition, allegedly, Beckley told another employee to, quote, "stop hanging around with those thugs." And finally, apparently, their fellow employee, Lolly Cornelius, was overheard telling another employee to, quote, "come over to the white side." And so they asserted that Robinson and Hall asserted that the reason that they stopped receiving deals from sales associates was because that they were black. So they filed after the fifth day. In the plaintiffs, Robinson and Hall, filed racial discrimination complaints with the controller for the automotive group, and then they left. The controller, Diane Holmer, began investigating and tried to set up a meeting between them, but Hall refused to come in. He rebuffed the efforts. Robinson did return, and Beckley apologized sincerely for the comments about "Make Priority Honda great again," as well as the thug comment. And yet, when Beckley presented Robinson with the new pay plan that demoted him to a sales associate, Robinson refused to sign. And that's, he was demoted because that effectively demoted to him to sales associate because he was standing away from the sales tower, and as a result, he was not getting the pay he should or that he deserved because sales associates were not bringing him leads. Apparently, and this is interesting, I'd love car dealerships to tell me more about this process because I don't know if this is common. I think it's really interesting. But the Priority Automotive sales associates sign new pay plans every month, and refusal to sign a new pay plan is a resignation. I think that's really interesting. I didn't know that pay plans changed on a monthly basis, and I certainly didn't know that you could treat it as a resignation. I mean, that's unique. It's not something you see in my worlds, and so I've never seen that before. Please leave a comment down below because I'm curious. And so they brought a bunch of state and federal claims suing under Title VII of the Civil Rights Act, alleging hostile work environment and disparate treatment. In addition, they sued for intentional infliction of emotional distress, as well as a negligent hiring claim and a conversion claim. And that's the most interesting part of it. We're going to talk briefly about their claims and what went down there. The hostile work environment only exists when the workplace is so permeated with discriminatory intimidation, ridicule, and insult that it would be reasonably perceived and is perceived as hostile or abusive. And so employees have to experience unwelcome harassment. It has to be because of the race. It has to be severe and pervasive. And it's very important. And much of the allegedly harassing conduct, according to the courts, didn't make it past the step two. They couldn't find that it was done because they were African American. And so the court declined on the hostile work environment. In addition, the court then reviewed the disparate treatment. And they couldn't make that finding either. The argument was that they were demoted because of race, but they have to provide direct evidence or develop an inferential case of discriminatory intent. But instead, it was pretty cut and dry. They were being moved because they were not getting the sales, and they were not getting the sales because they had not moved to the sales tower, which was a change. In addition, they went with the North Carolina law about intentional infliction of emotional distress claims. And it can't be just rough language or occasional acts that are definitely inconsiderate or unkind, but they have to be extreme and outrageous. And the court found that no reasonable jury could find that they had alleged conduct. Then Robinson and Hall said that they were negligent hiring, and they actually presented no evidence for negligent hiring. And this is the negligent hiring of Beckley. To prove that, it has to show that Beckley was incompetent when hired by presenting evidence of either his inherent unfitness for the position or prior act of negligence. And it's pretty substantial. But the last one, and why we're here today, is the claim of conversion. And so the plaintiffs allege that several items that they own and kept at the dealership in their desks were thrown out by Beckley and other employees on his orders. And Hall said he heard Beckley announce he threw all the desks out. And so there is no party contest that plaintiffs own the items. There was no argument there. And so as a result, the court remanded, they referred it for conversion or theft. And that's what's interesting here, because they threw out the employees' stuff, their employees' things in their desk or locker, they could be charged with theft. And that's what the Fourth Circuit Court found here. And I think that that is really interesting. You know, you should never throw your employees' stuff out. That's a bad idea. Store it for a reasonable amount of time, and then move on. But I think that this is an interesting situation of a business getting in hot water all over a theft. Let me know what you think in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.